Morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak to your attorneys before speaking on the record this morning, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, note that your attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present today, on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. Now, today is Thursday, and we have a very large docket to get through. I'm going to begin with the cases that have been requested to be called out of turn by the jails, and then we'll go to our sign-ins after we're done with that list. Let me see who we've got up first. For Maine, I have 3 cases to be called out of turn. First up, all right, on page 17, Raheem Williams.
Please approach, Judge.
Thank you. Good morning, Mr. Williams.
Good morning.
Mr. Williams, you're before the court this morning on 2 capiases for misdemeanor cases. These are related to charges for disorderly conduct and trespassing. I find probable cause. And Mr. Romero, what would Mr. Williams like to do today?
Judges, me, Mr. Raheem Williams, he advised me he wishes to resolve this matter. We wanted to see if the state had a plea offer for him today.
All right, let's see. Okay.
The offer on each count is withhold court cost, no return to Hunter's nightclub at 2262 Wilton Park Drive in Wilton Manors.
Let me discuss it with him.
Okay.
Judge, and speaking Mr. Williams, relaying the state's offer, he wishes to accept it.
Okay, all right. Mr. Williams, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Williams, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right, and Mr. Williams, what plea do you wish to enter? Guilty or no contest?
Yes.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence as to both matters will be a withhold of adjudication plus court costs. And remember, there will be the no return order to the nightclub that was discussed. And you understand that, sir?
Yes.
All right, thank you very much. Good luck to you. Next will be Christopher Dobbins on page 30.
He's approaching, Judge. He's here at me.
Thank you. Good morning, Mr. Dobbins.
Good morning, ma'am.
Mr. Dobbins, you're before the court this morning on one charge of battery on an officer, firefighter, or EMT. I find probable cause, and I will hear from the parties at this time. Okay.
I'm showing two priors out of the state of Georgia. Prior for reckless conduct out of North Carolina, communicating threats. Based on the allegations in this case, I'm requesting a $2,500 bond.
Okay. Mr. Romero?
Judge, in speaking with Mr. Dobbins, he did advise me he's not from here. He's been here in our community living for 3 months. He came down here in order to enroll himself in a program and try and get on the right track. My understanding is he's currently attending a program called Millennial. He says that program is still open to him. He could go back there, and that's where he wants to go back to. Now, he doesn't work. He gets disability. He gets approximately $763. From what he advised me, there's no one that's going to be able to afford to post his monetary bond. From what I heard from the state, he doesn't have an extensive record, Judge. What I'd be asking for the court to consider is releasing him pre-trial release, knowing Mr. Dobbins is going to be going back to this Millennial program.
Okay, well, I know that he wants to go back to the program, but I don't know that he's going back to the program. I don't know what the status of that is.
From what Mr. Dobbins advised me, he's still welcome there.
Yeah, I'm still welcome, ma'am.
Your Honor, but even if he was at that program when this happened, that didn't prevent this from occurring.
I understand. All right, I'm gonna set the bond at $1,500 in this case. And if that needs to be addressed or there's any other issues, then Mr. Dobbins can communicate that to his assigned attorney and handle it that way. Thank you. Next will be John Pierce on page 35.
He's approaching, Judge. Me.
Thank you. This is a change of charge. All right. Good morning, Mr. Pierce.
Good morning, Your Honor.
Mr. Pierce, you're before the court this morning on a change of charge. On count 6, I see that it was originally charged as attempted felony murder, and it's being changed to attempted first-degree murder. Is that correct, Mr. Linder?
Yes, Judge.
All right.
Judge Benson, at his original first appearance, found proof evident presumption great
Okay.
and ordered him to be held no bond. We just asked the court to adopt Judge Benson's previous finding.
Mr. Miller?
Objection, Your Honor.
All right. So, Mr. Pierce, since this is essentially a technical change, I'm going to go ahead and adopt the prior judge's ruling and replace the no bond hold on this count. I'm going to formally adopt the proof evident presumption great ruling as to this charge. But once again, for the record, that will be without prejudice for his attorney to file the appropriate motion and handle that before his division judge. All right, good luck to you, sir. All right, and then I have a few cases that were requested to be called out of turn from the other jails. Let me go to Conti. On page 18, Edison Celestin. Thank you. Good morning, Mr. Celestin.
Good morning, Judge.
Mr. Celestin, you're before the court this morning on some ad charges. Count 7 is for grand theft between $750 and $5,000. Count 8, illegal use of a credit card. Count 9 and count 10 are each a separate count for fraud, use, or possession of ID of another person without consent. And counts 11, 12, and 13 are felony probation violations which have no bond holds. I find probable cause, and Mr. Celestin, I do see you're going to have a hearing with your division judge tomorrow morning to address the violations of probation. As to the other charges, do the parties wish to be heard?
No, Judge.
Actually,
One moment, Mr. Celestin, hang on one moment. Mr. Miller, is the defense?
Judge, I spoke with him this morning and advised him that what just happened was going to happen,
Okay,
and there's really nothing that we can do for him at this moment.
okay, all right. Mr. Celestin, did you have a question?
Yes, you said I go to my division judge tomorrow
Correct.
for my violation of probation.
That's correct.
I actually have court for my violation of probation in April. So am I going to court for these new charges that's being put on me?
It'll be
tomorrow?
whatever your current violations are, that's what you'll be addressing with the division judge tomorrow.
All right, no problem.
All right, good luck to you.
All right, thank you.
You're welcome. Okay. Is,
Oh, I forget. I've been in contact with Steve Shea.
Yep.
And he said that he did the court would just send it to the division.
okay, that's fine. Which, is this Conti also?
Yes.
Okay, also at Conti on page 17, Eric Zayas. All
Yes,
right.
ma'am.
Good morning, Mr. Zayas. Okay, Mr. Zayas, you are before the court this morning on 3 ad charges. These are all misdemeanor capiases in municipal ordinance cases related to lodging, open container, and littering. And Mr. Zayas, what I'm gonna do is, they each have $25 bonds on them. I know that you have the other case as well. So I'm just gonna send these straight through to the division, and you'll see your division judge and your attorney probably within the next week, so you can address these, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
Thank you. Is there anyone else that needs to be called out of turn from any of the jail facilities? Okay. All right, so let's start going to our sign-ins. If we have them present. First up on page 3 is Caitlin Eady. There's family present. Is someone present on Miss Edie's case? Okay. Sir, are you here to observe or to speak? Okay, that's fine. All right. Good morning, Miss Edie.
Good morning.
Miss Edie, you're before the court this morning on 1 charge of aggravated child abuse. I find probable cause, and I will hear from the parties at this time.
Your Honor, I see no history for Miss Edie. That being said, I'm requesting a $25,000 bond. And I'm also asking that the court order no contact with any minors other than any minors that she may be her own children, Your Honor, considering that this did not occur with any of her biological children. Your Honor, this is based on the injuries suffered by the 4-month-old victim, which include a fractured skull, a broken arm. A doctor reviewed the injuries and determined that they were not consistent with her original explanation of what occurred. Another medical practitioner, Jessica Roche, who's a doctor of nurse practice with also an advanced practice registered nurse, conducted an interview, made a determination that the trauma the victim suffered, that the injuries were suffered as a result of physical abuse.
All right. Mr. Romero, we'll go to you.
Judge, I understand the facts and the circumstances surrounding this case are serious. I know Miss Edie knows it's serious. She's been here her whole entire life. She's 29 years old. As you heard, she has no prior contact with law enforcement. She's a registered voter. She's been here her whole entire life. Judge, we don't have any objections as far as the recommendations that the state has stated as far as no contact with any minor children except her own. Right now, she lives in Deerfield Beach with her husband. My understanding is her husband's a person that's going to help post her monetary bond. Judge, they rent. They do not own where they live. They've been paying a monthly rent. I believe the rent is somewhere in the proximity of $1,800. They live there with her husband and her brother. So they split that rent. Her husband making about $11 an hour. There's no way he's going to be able to afford the $25,000 bond. Judge, we're going to be asking for the court to consider setting a bond somewhere in the neighborhood of $5,000. So Ms. could hopefully have her family post that monetary bond on her behalf.
All right, taking everything into consideration, including the present allegations that have been made against Ms. Edie, as well as the fact that she doesn't have any prior criminal history, balancing those against each other. I'm gonna set the monetary bond in this case at $15,000. There will be an order of no victim contact. There will also be an order that Miss Edie have no contact with minors, except for any biological children that she may have herself. Miss Edie, so that you understand, number one, the no victim contact order. That means no being in the same place at the same time as this child. That would include the child's family. With respect to the no contact order as to other minors, other than any biological children you may have, that means no being in the same place at the same time or having any contact whatsoever with any child under the age of 18. Do you understand that, ma'am?
Yes.
All right, thank you very much. Good luck to you, sir. All right, next I have a sign-in on Victor Gonzalez, who is on page 16.
North Broward, Judge.
Thank you.
Yes.
Morning, Your Honor.
Good morning, Deputy.
Morning.
Good morning, Mr. Gonzalez.
Yes.
Mr. Gonzalez, you're before the court this morning on 3 charges. Count 1 is criminal mischief between $200 and $1,000. Counts 2 and 3 are each a separate count of resisting an officer obstructing without violence. I find probable cause for these charges. And ma'am, are you present just to observe this morning or just? Okay, well, I'm gonna say a few things to you that I say to everyone who comes to first appearances. Number 1, everything that we say here is being recorded and can be used against you and potentially him at a later date. Do you understand that? All right. Number 2, I am not addressing anything about the facts of this case or the background involved. I am only here to address bond and release conditions today. Do you understand that?
I understand, that's why
That's why I'm sorry? Can you speak into the microphone? It's a little bit hard for me to hear you.
Yes, I came here on behalf of the other tenants that he live, where I'm a landlord,
Okay, but are you here to talk to me about bond or release conditions, or are
No.
you here to talk about the facts of the case?
the facts.
Okay, then that's not gonna be for today.
Okay.
You can discuss that with the attorneys after today, okay?
Thank you.
Okay, I appreciate you being here for that, though.
Thank you.
All right, so at this time, I will hear from the parties with their recommendations.
Judge, I spoke with Mr. Gonzalez. He's happy with the bonds as set, and we'd ask the court to keep it there.
Okay. All right, I'm going to, I'll leave the $100 bond in place at this time.
Thank you, Your Honor.
All right, thank you. Good luck, Mr. Gonzalez.
Thank you so much.
All right. Next, on page 28, the B.D. Harris. Is he at Main?
Harris is at the main jail, Judge?
All right.
He's not here yet, Judge. If
Okay.
The deputies, they're looking for Mr. Harris on page 28. His private counsel is here
Yes,
present.
Mr. Lewis is here, so if you would just let me know when he's there and I'll call him back up. All right.
I will.
Judge, thank you.
All right. Going down the list. Next, if this person is present, Billy Lazowski. He's on page 25.
25.
His attorney is present.
No, he's not here, Judge. I believe the cutoff is page 20.
Okay.
But I will let the deputies know, and they'll bring him in right now.
All right.
Judge,
Thank
I'm
you.
his
Sure.
attorney, I know bond's already been set at 1,000, so,
Yes.
I'm just gonna just say that he's also gonna participate in Retreat Behavioral House. So his, wife wanted that part of the condition of release.
Well, I can't order him into doing it.
I understand, I just told her that I would bring it to the court's attention.
That's fine. All right. So there's no issue with the bond?
No.
Okay. Have you talked to Mr. Linder to make sure there's not going to be a
That is
reference?
correct.
All right.
There's no issue.
Okay. Then if you need to go, then that's fine. Otherwise, if you want to wait, that's fine with me.
Okay, are they bringing him up now?
Well, if you want to waive his presence, then I can have them do that and just have them not bring him. It's up to you.
He's on his way.
Okay, then I'll wait.
Okay. All right. Just let me know. Thank you. Okay. Next up, well, I doubt this one's there either, but I'm going to give him to you to put on the list. Bernard Flanders on page 30. His attorney is here as well.
Mr. Flanders, on page 30. They're gonna get him.
Thank
They
you.
put him on the list.
All
30.
right.
And,
Okay. All right. So
oh,
they'll call-
Judge,
yes.
Mr. what did I look? Harris on page 28 is here.
All right. Great. So we'll have Mr. Lewis come. I'll call you back up in a few minutes.
Come on, Mr. Harris, there's your private attorney, Mr. Lewis, come on. Okay.
All right. Good morning, Mr. Harris. Mr. Harris, you're before the court this morning on 2 charges. Count 1 is making, writing, or sending written threats to kill or injure others. Count 2 is an immigration hold. I find probable cause. Your private counsel, Mr. Lewis, is present with me in the courtroom this morning, and at this time I will hear from the parties.
Your Honor, and I spoke with Mr. Lewis about this matter. We both understand that Judge Casey set a $10,000 bond in the warrant.
Yes.
And that there's a no bond immigration hold. So I'm also, and I discussed this with Mr. Lewis, based on the seriousness of the allegations, I am going to be asking that should Mr. Harris post his bond and become eligible for release at some point, that he be supervised by pretrial release services with a GPS monitor. Based on the seriousness of the allegations at this point in time and some other information that's provided by Mr. Harris in the arrest warrant affidavit, I would request that it be level 1 at this point in time. Additionally, I'm asking for a release condition that Mr. Harris not be in possession of any firearms, weapons, or ammunition.
Judge James Lewis, on behalf of Mr. Harris, his mother just came and saw me last night.
Okay.
He does have a significant mental health history, Judge. I'd ask that he be screened in the jail for appropriate psychotropic medication. Okay. And I'd ask that you just leave the same conditions on that Judge Casey said in the warrant, which is a $10,000 bond. I don't think all of the GPS and the home house arrest and all that is necessary. I think he has basically no or very little criminal history. And
No, Your Honor, there's no history. My recommendation is based solely on the allegations in the arrest warrant affidavit.
Okay. All right. Here's what I'm going to do. I'll leave the $10,000 bond in place that Judge Casey set. If you would like for me to sign an order that he receive a medical screening or a psychological evaluation, that's fine with me if you want to prepare that, Mr.
I will,
Lewis.
Judge.
Additionally, based on the totality of the circumstances, if Mr. Harris does post a monetary bond, I'm going to place him on pretrial supervision with a GPS monitor, but it'll be a level 2 for the time being. And there will be an order that Mr. Harris possess no weapons, firearms, or ammunition until further order of the court. All right, and Mr. Harris, I just want to advise you, and I'm sure Mr. Lewis will discuss this with you further after today's hearing, but since you have the immigration hold, that has a no bond hold on it, which means that you'll go in front of an immigration judge to address that matter separately. All right.
thank you, Judge.
All right, thank you. Thank you, gentlemen. Good luck, Mr. Harris. Thank you. Okay. All right.
Judge, Mr. Flanders is here.
Perfect.
Mr. Flanders, come on up.
Okay, his private attorney, Mr. Shaw, is here.
Good morning, I'm Darren Shaw on behalf of Mr. Bernard.
There's your private attorney at the bottom center screen, okay?
Thank you. All right, good morning, Mr. Flanders. Mr. Flanders, you're before the court this morning on one charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause. Your private counsel, Mr. Shaw, is present with me in the courtroom, and at this time I will hear from the parties.
Your Honor, we have agreed to bond and release conditions if it's acceptable to the court.
All right,
The bond would be $6,000, no victim contact, no possession of any firearms, weapons, or ammunition. Counsel has provided me some additional information about his client. I checked, he has no criminal history.
That's correct, Your Honor.
all right, so I will approve that agreement of the parties. The monetary bond will be set at $6,000. There will be an order of no victim contact, as well as an order that Mr. Flanders possess no weapons, firearms, or ammunition. Mr. Flanders, I just want to make sure that you understand my orders with respect to the no victim contact order. Whether you know the alleged victim or not, that means no being in the same place at the same time as this individual. That includes no phone calls or text messages to this person and no third-party contact or social media contacts. Do you understand that?
I do understand that.
All right, and additionally, with respect to the order that you possess no weapons, firearms, or ammunition, that means if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
I do understand that.
Okay, all right, thank you very much. Good luck to you, sir.
Judge, his parents are both present in the courtroom today,
Okay,
but they don't want to say anything.
okay, that's fine.
Thank
All
you.
right, thank you very much.
Thank you.
And Judge, Mr. Lazowski is here now.
Perfect.
Mr. Lazowski, come on up. There's your private attorney up there. In the bottom center screen. That's your
All right. Good morning, Mr. Lazowski. Mr. Lazowski, you're before the court this morning on two charges. Count one, possession of heroin. Count two is first-degree petty theft. I find probable cause. Your private counsel is with me in the courtroom, as you can see, and I'll hear from the parties.
Judge, with the understanding that the $1,000 will be posted, he's also going to be going to Retreat Behavioral House in Lake Worth,
Okay.
and he's also going to go to Harmony Hills thereafter.
Okay.
And we'll be posting the bond.
Okay. Anything further from the state?
Yes, Your Honor, and Ms. Reisman's advised me about the rehab he's going to be going to, and no objection from the state.
Okay. All right, so in light of that information, I'm gonna leave the standard bond in place, and Mr. Lazowski, I wish you luck with those programs. All right, thank you to everyone.
Thank you, Court.
Okay. All right, I have one more sign-in, and
No
that is
problem, Judge.
going to be on page 9, Willie Darden, who has family
Mr.
present in
Darden
the
is here.
courtroom.
Come on up, Mr. Darden.
Darden, on page 9. All right, good morning, Mr. Darden.
One.
You're before the court this morning on two charges. Count one, robbery by sudden snatching without a firearm or weapon. Count two is touch or strike battery, domestic violence. I find probable cause, and before I hear from the parties, ma'am, are you here just to observe this morning or to speak?
To speak.
Okay, and you heard everything that I said earlier, correct?
Yes.
All right, so we're only talking about bond and release conditions, right?
Yes.
Okay, so if you want to speak, I'm going to place you under oath, and I'm going to ask you to speak into that microphone so that they're able to hear you at the main jail, okay?
Okay.
All right, to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
And you can put your hand down now, and will you please state your full name for the record?
Deandra Grubbs.
How's the last name spelled?
GRUBBS.
Grubbs, okay. All right, Ms. Grubbs, what is it you would like to tell us today?
Is it possible for Mr. Darden to, he lives with me, so if he doesn't have contact with the plaintiff, I guess, is that okay for him to have terms, not to have contact with her and be set out on bond?
Well, there will very likely be a no victim contact order in this case, if that's what you're asking me. And as for the bond amounts, what will happen is I'm gonna listen to the two attorneys and hear their recommendations, and then I'll make a decision as to that. Okay? All right, anything else? Okay, all right, so now, Mr. Linder, we'll go to you.
Thank you, Judge. Your Honor, I'm requesting a $2,500 bond on each count, no victim contact.
Okay.
Mr. Darden was arrested in 2018 for domestic violence battery by strangulation, felony batteries due to priors, violation of a domestic violence injunction against the same alleged victim. Those charges were dropped. Also in 2018, he was arrested for violation of pretrial release conditions, that being a no contact order. That charge was also dropped. One moment. I'm showing under the name Chris Wilfork, which is one of his listed aliases on the booking sheet. He had prior aggravated assault on a law enforcement officer, grand theft, resisting with violence. At a date from 2000, he was sentenced to 1 year and 8 months state prison. Additionally, prior sale or delivery of cocaine. I'm also showing aliases under the names Sean Harvard, Raymond Darden, Terry Williams, Trell Williams, and Darden William.
Okay. Mr. Romero, we'll go to you.
Judge, after speaking with Mr. Darden, I think there's more to this than what's written on the PC affidavit. My understanding is right now the alleged victim and Mr. Darden do live apart. He is right now residing with his cousin. He's grateful his cousin is here helping him through this ordeal. My understanding is or his family is going to help post his monetary bond. Mr. Darden is not working at this time. He receives disability. He gets approximately $690 a month. He's 42 years old, been here his whole entire life. More importantly, from speaking with Mr. Darden, my understanding is that the alleged victim on this case is currently a defendant on an open matter in which Mr. Darden is
Objection,
the
Your
alleged
Honor.
victim. I believe that's relevant, goes towards motivating as far as maybe why we're here. My understanding is I believe that case is actually coming up pretty soon. Having said that, Judge, based on the totality, I'm going to be requesting a $1,000 bond on Mr. Darden's behalf on counts 1 and 2.
Bond on each count will be set at $1,500. There is going to be an order of no victim contact. Mr. Darden, so that you understand the no victim contact order with respect to the alleged victim in this case, that means no being in the same place at the same time. That includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, ma'am.
Thank you. How long do I have them for? We find out. Okay. All right, so now I don't have any other sign-ins for the time being, so we're gonna just start going down the regular list. First up will be Akela Baptiste.
No problem.
Okay. Good morning, Ms. Baptiste.
Good morning.
Ms. Baptiste, you're before the court this morning on 3 charges. Count 1, touch or strike battery, domestic violence. 2, trespassing on an occupied structure or conveyance. 3 is a felony probation violation, which has a no bond hold. I find probable cause. Ms. Baptiste, as to the probation violation, I do see you're going to have a hearing with your division judge tomorrow morning on that matter. And at this time, I will hear from the parties with their recommendations as to count 1.
Requesting a $1,000 bond, no victim contact on count 1.
All right.
Judge, in light of the no bond hold, we're going to reserve any bond arguments for another day.
Okay. All right, so on count 1, the monetary bond will be set at $1,000. There will be an order of no victim contact. Ms. Baptiste, so that you understand the no contact order as it pertains to the alleged victim in this matter, no victim contact means no being in the same place at the same time as this person. That includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that, ma'am?
Yes, but I don't understand why they had me down for a battery trap where I didn't put my hands on. I was just
All
trying to get
right.
my.
Well, ma'am, I don't want you to say anything else about it. Just know you're gonna be seeing your division judge tomorrow, so you can discuss it with your attorney, all right? Good luck.
Okay. Thank you.
All right, I'm going to, I know, Mr. Romero, I know we've got somebody there. Give me 5 minutes. I just need to take a 5-minute recess, okay? Okay, we are back on. I know that was longer than 5 minutes, but we're ready to roll through the rest of the docket. So my next up is Shavaris Johnson.
She's approaching, Judge, here at Main.
Thank you.
Come on up.
All right, good morning, Ms. Johnson.
Good morning.
Ms. Johnson, you're before the court this morning on 2 charges. Count 1 is operating without a valid license. Excuse me. Count 2 is an out-of-county misdemeanor hold that's out of Palm Beach County and has a no bond hold on it. I find probable cause. And do the parties wish to be heard on count 1?
Judge, I believe I spoke, my colleague, he spoke with the state, I believe, extended an offer of withhold. Court cost, Mrs. Johnson is accepting that offer.
Okay, Mr. Linder, is that accurate? Okay, all right, Ms. Johnson, I'm gonna ask you a few questions before we're done. So to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Ms. Johnson, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Ms. Johnson, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence as to count 1 will be a withhold of adjudication plus court costs. Good luck to you, ma'am. Brianna Washington.
Northbound.
I'm sorry, she's medical reset?
Yes, ma'am.
Okay, thank you, deputy.
Welcome.
Can I have the next one? Next up is Stacy Grakowski.
Medical reset.
All right. Perlene Valbrun.
Yes, that's me.
All right, good morning, Ms. Valbrun. You're before the court this morning on 1 charge of violation of an injunction for stalking. I find probable cause.
Actually, Judge, I was going to argue against probable cause.
Go ahead.
This is a misdemeanor, and the law, in order to arrest someone for a misdemeanor, in order to arrest someone without a warrant for a misdemeanor, law enforcement has to observe all of the elements of the crime. And in this case, according to the probable cause affidavit, they observed her walking out of the area, leaving the neighborhood. There's no indication when they made contact with her that she was within 500 feet of the residence that is protected. And so there's no probable cause to hold her for violating an injunction. We don't know where she was. We don't know how far away she was. I understand that there's video evidence and doesn't preclude the state from going forward with charges. But in order to effect an arrest and therefore hold her, the police have to observe everything that happened, and they didn't. So I'm arguing there's no probable cause, and I would ask the court to release her on her own recognizance.
All right, Mr. Linder, state's response.
Thank you, Your Honor. Florida statute 901.15, which deals when an arrest made by an officer without a warrant is lawful, clearly states in... One moment, Your Honor. Subsection 6, there's probable cause to believe the person has committed a criminal act which violates an injunction for protection.
I'm going to withdraw my argument in probable cause, Judge. Ms. Valbrun has been living in South Florida for 25 years. She's 17 years at her current address. She works for Canner and Pentaglia. She's been there for about 4 months. In addition to that, she advises she's at law school and at Nova Southeastern and studying for her MBA. I didn't see any priors for her, so I'd ask the court to consider releasing her with a minimal bond. $1,000 should cover.
Okay.
Concerns that Ms. Valbrun has mental health issues. She was arrested February 22nd for misuse of 911. The allegations in this case was that she'd been drinking. Her mother had her car keys and didn't want to give them to her, so she called 911 to report that her keys were stolen. She was explained by law enforcement that they were not going to do a theft report. She called 10 minutes later, wanting to know why a theft report hadn't been done. She then called again at a later time, claiming she was sexually assaulted by her sister. This was a false report. When law enforcement got there, she agreed to go to sleep and get her keys in the morning. She then called again.
This came into first appearances.
It did, and she was transferred to Judge Lerner Wren. She's actually was supposed to have she's scheduled for a status conference this morning before Judge Lerner Wren.
I don't know why we're relitigating the case that she was out on.
Well, Your Honor, I wasn't done.
Oh, sorry.
I'm not relitigating, I'm just bringing the allegations, because if I'm gonna make a claim that I have mental health concerns, I'm gonna back that up with actual information, not just speculation.
Not objecting to this case being transferred to Judge Lerner Wren.
Well, one, I don't know that this case can be transferred to Judge Lerner Wren, Your Honor. I don't know the circumstances behind the injunction. I am gonna be requesting a $2,500 bond and no victim contact, obviously. If she's gonna be represented by the public defender, they can seek appropriate remedy as far as mental health issues.
Since it deals with the injunction, I'm not sure that I can transfer it directly to Judge Lerner Wren. But that's definitely something that her attorney can bring up. All right, I'm gonna set the bond in this case at $2,000. There will be an order of no victim contact. Ms. Valbrun, so that you understand the no victim contact order, I understand that there is a restraining order in place, so you need to understand that whatever requirements are in place as a result of that restraining order, they are still in place. In addition to that, I'm going to say to you for clarification, the no victim contact order means you are not to be in the same place at the same time as the alleged victim in this case. There will be no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes.
All right, thank you.
Judge,
Yes.
North Broward asked if you could call
Come on, Mr. Evans.
Mr.
Is it Barnett?
Barnett, page 11. Mr. Barnett is willing to resolve this case if the court is so inclined.
Okay, let me just get his paperwork. All right, good morning, Mr. Barnett.
Good morning, Judge.
Mr. Barnett, you're before the court this morning on 2 charges. Count 1, trespassing, failing to leave property upon order by owner. Count 2 is a misdemeanor capias that is also related to trespassing. I find probable cause. And Mr. Leonard, does the state have an offer in this case?
Yes, Your Honor, to resolve both cases, the offer being adjudication time served, no return on the Capias case, the no return would be to Walgreens at 1101 East Atlantic Boulevard in Pompano Beach.
All right. And just for the record, the no return on the new case would be to St. Coleman's Church on Federal Highway in Pompano Beach.
That is correct.
All right, Mr. Barnett, I'm just gonna repeat that again so I know you heard it, okay? The offer to resolve both of these cases would be an adjudication of guilt with time served. There would be no return orders in both cases. One of them will be to the Walgreens that was discussed, and the other is to St. Coleman's Church. Do you understand that?
Yes, Your Honor.
Do you wish to accept those offers?
I accept, Your Honor.
Okay, all right. Do you swear or affirm to tell the truth?
Swear to affirm and tell the truth.
Okay, very good. All right, so Mr. Barnett, do you understand everything we've discussed so far this morning?
So far, yes, Your Honor.
All right, you can leave your
Oh,
hand
it's
down. You can leave your hand
Okay.
down. All right. Is anyone forcing you to resolve these matters?
No, Your Honor.
Okay. Are you under the influence of drugs or alcohol?
No, Your Honor, I'm not.
All right. Do you need any more time to speak with your attorney?
No, Your Honor. No contest for me.
Okay, we'll get to that one. Hang on, okay? Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
A plea of no contest, yes, Your Honor.
Okay. And have you ever been treated for mental or emotional illness?
No, Your Honor.
All right.
Never.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, Your Honor, I understand.
All right. And Mr. Barnett, you said that you wish to enter a plea of no contest. Is that correct?
Yes, Mrs. Judge Amanda.
Okay. All right. I accept your plea and find that it is freely and voluntarily given. Once again, your sentence in both cases will be an adjudication of guilt with time served, and the no return orders will be in place as we discussed. And you understand you're not to go back to those locations?
Understood, Your Honor.
Okay. All right. Thank
understand.
you. Good luck to you, Mr. Barnett. Thank you.
Thank you, Mrs. Amanda Carson.
You're very welcome. Okay. Next up, I'm not sure if this person's gonna be present or not, but I assume he's gonna be at Maine. On page 27, Eric Wendell Hunter has family present in the courtroom.
He's here, Judge.
Okay.
Approaching. Mr. Hunter, come on up, please.
All right. Good morning, Mr. Hunter.
Good morning.
Mr. Hunter, you're before the court this morning on one charge of throwing a missile into a dwelling, vehicle, building, or aircraft. I find probable cause. And before I go to the parties, ma'am, are you here just to observe this morning or to speak?
To observe.
Okay. All right. That's fine. So then Mr. Linder will start with the state's recommendation, and then I'll go to Mr. Romero.
Just need one moment, Judge.
Okay.
Your Honor, see prior arrests, it looks like most of them were dropped. I'm going to be requesting a $5,000 bond. This is based on the allegations. Injuries suffered by the victim as a result of Mr. Hunter's actions. I'm also going to be requesting an order of no victim contact.
Mr. Romero?
Judge, I was trying to speak to Mr. Hunter. I was explaining to him, basically, the reason why we're here is to just get a reasonable release conditions. Not here on the, it's not his trial date today, but he is looking forward to having his day in court. And speaking with Mr. Hunter, the state did confirm he is not a convicted felon. He's a registered voter in our community. He's been residing here, I believe, since 1996. He's 53 years old. He lives with his wife and daughter. My understanding, they live locally here in Miramar. He's in the processes of applying for disability. Judge, he isn't, from what he advised me, he's not going to be a flight risk at all. He's looking forward to contesting these allegations. My understanding is, and I don't know what the PC affidavit says, he contacted law enforcement I'm assuming the victim contacted law enforcement as well. I don't know if that's mentioned there. I believe there's more to this story, but I'm going to be asking for a $2,000 bond, Judge.
All right, I will set the bond at $3,000. There will be an order of no victim contact. Mr. Hunter, with respect to the no contact order, as it pertains to the alleged victim in this case, whether you know this person or not, please understand the no contact order means no being in the same place at the same time as this person. That includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, thank you very much. Good luck. Thank you, ma'am. All right, next up is Rachel Foti.
She's approaching, Judge. She's here, ma'am. Come on up,
Thank
ma'am.
Good morning, Ms. Foti.
Good morning.
You're before the court this morning on 2 misdemeanor capiases. These are both related to petty theft charges. I find probable cause, and I will hear from the parties.
Judge, and speaking of Ms. Foti, my understanding she was extradited. I believe she's been in custody since December. She was extradited from Lake County. She did a county sentence. Now everything's done. She's under no form of supervision. Considering this is a 2017 case, she's wanting to see if the state has a plea offer for her today.
Okay.
One moment. Your Honor, I can advise the court. The prosecutor assigned to these cases have documented significant jail offers based on Ms. Foti's history. She has a substantial amount of prior thefts. Just so Mr. Romero and Ms. Foti are aware, the offer on one case is 90 days in county jail, the other is 60 days.
All right, Mr. Romero, based on that information, do you have anything you want to add?
Judge, I don't know if the court would want to get involved. I'm assuming those notes are, and I'm just speculating, this 2017 case, maybe it's from 2017, so I don't know really the strength of the state's case at this time. I don't know if the court would consider getting involved and extend an offer of a time served on Ms. Foti's behalf to Ms. Foti.
Because I don't have any of the information in front of me on those two cases, I realize they're 2017 cases, but since I don't have that information in front of me, I'm not comfortable with doing that at this time.
I understand. In that case, then I just ask you to leave it alone, and Ms. Foti will bond out.
Okay, all right. Anything further from the state?
No, Judge.
All right, I will leave the bonds in place as they are then. Good luck, Ms. Foti.
Foti.
Okay. I I have someone else that's signed in, Mr. Romero. I'm not sure if you have him. He's on page 30, and that is Asif Mohammed Khan. His private counsel is present in the courtroom.
Mr. Khan.
I'm sorry?
Mr. Khan. He's not here yet, right?
Okay, he's not there.
He's not here. They're going to get him right now.
Okay, just let me know when he's ready. Thank you.
I will.
Okay. All right, next will be Priscilla Johnson.
She's approaching, Judge.
Thank you. All right, good morning, Ms. Johnson.
Good morning.
Ms. Johnson, you're before the court this morning on 5 charges. Count 1, false ID given to law enforcement. 2, possession of cocaine. 3, failure to register a motor vehicle. 4, driving while license suspended, third or subsequent offense. And 5 is for being in possession of counterfeit license plates or validation stickers. I find probable cause, and I will hear from the parties if they wish to be heard.
Yes, Judge. I'm going to be asking for pretrial release. I'll ask to see if the state has an objection before I proceed.
Your Honor, I'm showing she lives in Michigan, so I don't think pretrial would be appropriate.
Judge, she no longer lives in Michigan. She's been residing here in South Florida for now 1 year. She's 31 years old. At this time, she is going to school. She attends the Institute of Avita. It's on Davie on University Drive, where she's studying cosmetology. She's been going to school there for about 1 year now. She goes to school Tuesday, Wednesday, Thursday, Friday from 8 a.m. to 3 p.m. She lives here locally in Miami. She's been staying at the same apartment now. Her rent is $685. My understanding is she has prior contact with the criminal justice system, but it's been a couple of years, Judge. So considering these are all nonviolent offenses, Judge, she is working and living here. That is why I'm asking if the court would consider releasing her on pretrial release.
Your Honor, I don't know how much confidence the court can have. She's giving a false name. She's got the registration in the name of someone else that she's presenting as her. When she's asked if she has a driver's license, she tells the officer, yeah, she has a license in 3 different states. Finally, she's asked about her social security number, and at the age of 31, she advises she doesn't know it off the top of her head. Finally, when every attempt she's made to pass herself off as someone else is thwarted, she finally then decides to give her real name. I just don't know how much confidence the court can have in any information she's providing today.
Well, if
That's
she...
the only thing that I can say that certainly the state can verify at this time. My understanding is Ms. Johnson has been clean for about 10 years now. She is a registered voter in Dade County. So, Judge, based on those two, which I believe the state attorney can go ahead and verify those 2 pieces of information, Judge, I'd be asking for the court to consider releasing on pretrial. Now, I do understand as far as some of the allegations that the state has talked about, but that led to her arrest, and that's why she's here. But she can't at this time contact anyone post her monetary bond. That's why I'm asking her to be released in her supervision.
Okay, well, I'm going to have Mr. Linder confirm the information that you just gave me. And if that does check out, I will tell you that if she were going to be on pretrial, it would be pending verification of that address.
And,
So,
Your Honor, I'll
go
look
ahead.
up based on the information that's been provided.
Yes.
But that won't necessarily confirm anything at this point in time.
I understand.
Because so much false information has been given.
I understand. With what you have.
Judge, and while the state looks, I was just talking to Ms. Johnson as far as the added stipulation regarding verification. I did advise her that some pretrial would be verifying and would have to contact someone who has basically kind of authority over the premises to verify where she lives. And she advised me that's not gonna be a problem. So at this time, in anticipation of that, that's not gonna be a problem.
Okay, all right, I'm just waiting to verify that information with the state now, so just give us a moment.
I'm getting some old priors out of Illinois. That's really all I'm showing here.
Okay. All right, well, we've all discussed all the information and concerns going on here today, and Mr. Romero, I'm sure you've done a good job of explaining to Ms. Johnson what's gonna happen if she doesn't comply with what needs to happen here, so, Ms. Johnson, at this time, I will, you'll be ROR'd and placed on standard pretrial supervision pending verification of the address. So that means that pretrial will have to either call or go to that location in order to confirm that that is indeed the residence that you have been living at or will be living at. So that you understand, and I'm sure Mr. Romero has told you this already, if they are not able to verify that information, then the bonds will remain in place as they are currently set. Do you understand that?
Yes.
All right, thank you. Yanni Campbell,
North Broward.
thank you. North Broward, do you have Riani Campbell? I don't, thank you, Deputy.
North Broward, Your Honor. You're
All
welcome.
right, good morning, Ms. Campbell.
Good morning.
Ms. Campbell, you're before the court this morning on 6 charges. Count 1, grand theft between $750 and $5,000. 2, passing a forged or altered bill or promissory note. 3, fraud, attempting to use ID of another person without consent. 4 is fraud, impersonation, use, or possession of ID of another to harass. 5, accessory after the fact of first-degree felony. And 6 is exploitation of an elderly individual under $20,000. I find probable cause for these charges, and I'll hear from the parties at this time.
Your Honor, based on the allegations, I'd be requesting a $7,500 bond on count 6. No victim contact. Also noting in 2013, Ms. Jackson had a burglary of a dwelling with a battery.
Mr. Miller?
Yes, Judge. I did speak with Ms. Campbell earlier this morning. She is a lifetime resident of South Florida. She's been living at her current address for about a year. She's unemployed. Her husband supports her and her 3.5 children. She's got one on the way. And so count 6 seems to be a little high because the defendant in this case, or Ms. Campbell's never had contact with the alleged victim. And I understand that the principal theory, but she never actually had any contact. And so I would ask the court to reduce that bond to $1,000 and keep the remainders as set.
All right, I'm going to set the bond on count 6 at $2,000, and I will leave the other standard bonds in place. In an abundance of caution, there will be an order of no victim contact. Ms. Campbell, with respect to the no contact order, whether you know the alleged victim or not, understand that that order means no being in the same place at the same time as this individual, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand?
Yes.
All right, thank you. Cassandra Jackson.
Court is ready.
Oh, I'm sorry?
The person on page 30, Mr. Nan, is here present. Khan, sorry.
Okay, all right, we'll go ahead and do his case because his counsel's present.
Mr. Khan, come on up. There's your private attorney coming up to the podium right now.
All right. Good morning, Mr. Khan.
Morning, Your Honor.
Mr. Khan, you're before the court this morning on 2 charges. Count 1, loitering or prowling. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause. I do see that you have a hearing with your division judge tomorrow morning to address the violation of probation, and your private counsel is present with me in the courtroom. At this time, I will hear from the parties, if they wish to be heard.
Good morning. My name is Pat Curry. Myself and my wife have represented Mr. Khan before, and somebody called us, I think it was Mr. Miller, to indicate that Mr. Khan was on the docket. I guess they probably saw our appearance some time ago. I don't think the law enforcement officer can make an arrest for a misdemeanor not committed in his presence, and I don't think there's any exception in the statute. I was also trying to look over the public defender's shoulder to make a finding for loitering and prowling. These are things that the police officer must observe himself. He observed none of them. I don't think there's probable cause. I disagree with the court. I don't think there was reasonable suspicion to even stop his vehicle. And I don't think the giving of the Miranda warnings in the case somehow cleanses the initial error by the law enforcement. I don't think there's probable cause. I think it's an illegal arrest. I think he's a problem with the fact that statements he gave still didn't do anything. He was in a lawful car. There was no drugs on him. There was no firearms on him. That was a 2018 BMW. He obviously knew somebody in the neighborhood or the girl. I'm asking that you find no probable cause. I know the non-adversary thing is over with, but I'm going to ask that you find no probable cause, and if there's no probable cause and there's no affidavit or warrant, I think he should be released on the violation of probation as well.
Your Honor, the officer did have reasonable suspicion to stop the car. It matched the car that the complainant called in and referenced to the individual, the suspicious vehicle, that the driver of the vehicle had been walking around the complex dressed in all black and with a shaved head. Once he stopped the vehicle and saw that Mr. Khan matches the description, he certainly has a right to investigate the suspicious person call, as per loitering and prowling statute allows. He has to issue a Miranda warning at that point in time, Your Honor, because Mr. Khan has to be given an opportunity to dispel the concerns for the officer. Clearly, he could not, based on the information he was providing that was proven to be false, based on the officer's contact with the multiple residents in these apartments that Mr. Khan claims to have been visiting for a rendezvous.
Okay. Respectfully, I'm going to leave my finding of probable cause in place at this time. Is there anything further the parties wish to be heard on?
Just ask that the court order no return to 9157 Northwest 38th Drive in Coral Springs.
Is there a bond on this?
$25, but he's got a no bond hold.
I understand. He's in front of Bailey tomorrow?
Correct, tomorrow at 8:30.
Mr. Khan, if you want us there, call the office, okay?
All right.
Okay.
All right, so I will put the no return order in place for the time being. So, Mr. Khan, the no return order applies to that apartment complex, so just know until further order of the court, you're not to be there. Do you understand?
Yes, Your Honor.
Okay, all right, thank you very much. Good luck to you, sir. Thank you, Mr. Curry.
Thank you.
All right, next will be Cassandra Jackson. Shit, North Broward. Oh, no, she's right there.
He's here.
Thank you. All right, good morning, Ms. Jackson.
Good morning.
Ms. Jackson, you're before the court this morning on 6 charges. Count 1 is grand theft between $750 and $5,000. 2 is passing a forged or altered bill or promissory note. 3, fraud, attempting to use ID of another person without consent. 4, fraud, impersonating, using, or possessing ID of another to harass. 5, accessory after the fact of a first-degree felony. And 6 is exploitation of an elderly person under $20,000. I find probable cause, and I will hear from the parties.
Your Honor, you said a $2,000 bond on our co-arrestee. If the court believes that is an appropriate bond in these circumstances, I'd ask that you set the same bond. No victim contact.
Mr. Romero, anything you want to add?
Judge, if I heard correctly, the co-defendant was set at $2,000 on count 6.
That's correct.
So at this time, nothing to add.
Okay. All right, I'll set the bond at count 6, in this case at $2,000 as well. There will be an order of no victim contact. Ms. Jackson, so that you understand the no victim contact order, with respect to the alleged victim in this case, whether you know this person or not, please understand that that means no being in the same place at the same time as this person. That includes no phone calls or text messages, and no third-party contact or social media contact with this person. Do you understand?
Yes.
All right, thank you. Teresa Crane.
Medical reset, Judge?
Okay, I've reset her a couple times now, so I'm gonna go ahead and make a finding of probable cause, and we'll have her reset for bond.
Thank you, Judge.
Tammy Lewis.
Judge, she's at North Broward, but I'm told that she's actually in court this morning.
Yes.
Okay. All right, well, she's probably in court on the, either the KPSs or the VOPs, so we'll just have her reset for the other two. All right, Monica Mito.
Judge, Ms. Mito refused.
Okay,
In light of the fact that this is an out-of-state hold, I would not be objecting to the court passing this through.
okay. All right, then in Ms. Mito's case, I'll make a finding of probable cause in absentia. That way she'll be able to go to the extradition judge. Thank you. Samuel Hamilton.
Broward?
All right, good morning, Mr. Hamilton.
Yes.
Mr. Hamilton, you're before the court this morning on 4 charges. Count 1, domestic battery by strangulation. Count 2, assault. Counts 3 and 4 are each a separate count for a felony probation violation, which have no bond holds. I find probable cause. Mr. Hamilton, I do know you're gonna have a hearing with your division judge tomorrow morning to address the violations of probation. And
Yes, ma'am.
at this time, I'll hear from the parties on count 1.
Your Honor, I'm requesting a $15,000 bond on count 1,
Okay.
$500 bond on count 2. It's based on the level of violence. This was witnessed by an independent witness who intervened and stopped Mr. Hamilton. I don't know how far this would have gone if he had not.
Judge, in light of the no bond holds, we're not going to object.
All right, so on count 1, I'll set the bond at $15,000. Count 2 will be $500, and there will be an order of no victim contact.
Your Honor.
One moment, Mr. Hamilton. Okay, Mr. Hamilton, before you say what you want to say, let me say something, okay? I don't want you to say anything about the background or facts of this case, because I'm only talking about bond and release conditions today.
I understand.
All right, and you're going to be seeing your division judge tomorrow anyway. Do you understand?
Mm-hmm. I was just, I don't have like $15,000. Right now I'm working from job to job. I've supposed to been doing a plumbing job. I really don't have that much money. I don't have money coming in like that.
I understand what you're saying to me, Mr. Hamilton, but since right now you have a no bond hold on the violation of probation anyway.
understand that.
So the division judge is the one that's gonna have to address it, which is why this is being set the way that it is, just so that you understand, all right? So you'll be able to address it more tomorrow,
Would he
okay?
be able to address the $15,000 bond?
Yes, they can talk about it. They can talk about it. Okay?
Okay.
All right, so Mr. Hamilton, before you leave me, there's going to be a no victim contact order in place that applies to both of the alleged victims in this case. So I need you to understand that
can
that,
I,
hold
say
on,
something?
hold on. I need you
Well,
to,
the
wait,
incident
Mr.
happened at my
Hamilton,
residence.
Mr. Hamilton, I need you to listen to me for a minute, okay? Just listen.
Yes, ma'am.
All right. The no contact order means no being in the same place at the same time as either of these people. That also means no phone calls or text messages to them, and no third-party contact or social media contact with either of them. Do you understand that?
Yes, ma'am.
Okay, all right, and everything else can be addressed tomorrow morning, so you're gonna deal with that then, okay?
Okay, I was just saying, they had came to my residence.
Okay, I don't want
I
you
was
to
at
say,
home,
I don't want you to
and
say
they came
anything
and
else
attacked
about
me.
it. Don't say anything else about it, all right? We'll talk to your attorney about it tomorrow morning, All right, good luck to you, sir.
Judge, I'm sorry before he goes. Mr. Hamilton, were you
Oh.
injured as a result of your arrest?
Huh?
Were you injured?
Yes, I was injured.
Do you have visible injuries as a result of
I
your
have
arrest?
visible injuries
Judge,
to my
I'm
head,
requesting a
and
photo
my
order,
arms,
please.
and my hands.
All right, I'm gonna sign a photo order so that they can photograph the injuries. All right, good luck to you, Mr. Hamilton.
Yes, ma'am. Thank you, Your Honor.
You're welcome. Next will be David Brendis. Thank you.
He's approaching, Judge.
Thank you very much. Good morning, Mr. Brendis. You're before the court this morning on one charge of felony battery, domestic violence. I find probable cause, and I will hear from the parties.
Your Honor, I'm requesting a $15,000 bond, GPS monitor, no victim contact. Noting that Mr. Brandis broke the victim's nose in this case when he punched her in the face. His criminal history includes out of the state of New York. In 2013, he was convicted of contempt for violating an order of protection. 2013 and 2010 DWI. 2000 reckless endangerment. 1994 assault. And I do see a woman in 2004 in Broward obtained a non-expiring order of protection injunction against Mr. Brandis.
Okay. Mr. Romero?
One moment, Judge. Judge, my understanding is Mr. Brindis and the alleged victim do live apart. He actually lives in his own place in Pompano Beach, where he's been residing for about 8 years now. Right now, he's looking for employment. He's not working. His family's helping him out. I'm going to be...
I own a store in New York State with my father, and that's where I work, and I fly back and forth. I go back at least once a month, and I do all my ordering from here on a weekly basis.
Okay, so that I didn't understand. He basically has his own business, Judge. He has a store in New York that I believe his family helps him run.
No, I own it. I've been owning it for 13 years, Old Village Wine and Spirits.
So, Judge, at this time, and speaking, Mr. Brindis, I don't think the monetary component is a problem, the $15,000. What we're going to be asking for the court to consider is placing him on standard as opposed to level 2. From what he advised me, his job requires him to travel back and forth to New York. So that's why we will be asking for the court to consider a standard pretrial as opposed to level 2.
Okay. All right, that's fine. So the bond in this case is going to be set at $15,000. If Mr. Brendis posts the monetary bond, he will be placed on pretrial supervision. That'll be standard pretrial with no GPS requirement. And there will be an order of no victim contact. That's fine. All right, Mr. Brendis, so that you understand the no victim contact order with respect to the alleged victim in this case, that means no being in the same place at the same time as this person. That also means no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand that?
Absolutely.
All right. And I am going to, since he's going to be on pretrial, I'm going to permit him to leave the Tri-County area, but only for work purposes. Understood?
That's fine.
All right.
Yes, ma'am. Sorry.
Thank you. All right. Next will be Jose Juarez Thomas.
Judge, he requires a Spanish interpreter. I believe my colleague already contacted the
Okay.
interpreter's office.
Okay.
Tomás, siéntese.
I'll put him on recall. All right. Next will be Jairo Sanchez.
medical.
Okay. Devin Dixon,
He's approaching Judge here in Maine.
okay. He's a medical reset. All right, good morning, Mr. Dixon.
Good morning, Judge.
Mr. Dixon, you're before the court this morning on one charge of felony battery, domestic violence. I find probable cause, and I will hear from the parties.
One moment, Judge.
Okay.
Your Honor, I see no history. I'm also going to be seeking a $15,000 bond in this case. No victim contact, considering that Mr. Dixon fractured the victim's orbital bone when he struck her in the face.
Judge, in speaking to Mr. Dixon, unfortunately, he's not going to be able to afford to post any sort of monetary bond. He's 54 years old, been living in our community for well over 15 years plus. He works when he can. He works in an electrical company. He says part-time, and it's not very much. He gets about $13 an hour now. He does understand. I did advise him. There's going to be a no-contact order in place. He will abide by that contact order. He's going to have to find a separate place to live, separate and apart from the alleged victim. Judge, but right now, from what he advised me, he's really not going to be able to afford to post a monetary bond.
Well, I'm not going to ROR him based on the allegations today, so if he's not able to afford any monetary bond, then this may be better suited to go in front of the division judge so there can be a lengthier hearing to address the bond issue.
Judge, he's asking, he may be able to get in touch with his friend that if the court were inclined to set about a $1,500 bond, that's something he might be able to afford.
Based on these allegations, and I understand their allegations, this is just first appearance, but based on the injuries that were sustained by the alleged victim in this case, I'm not comfortable with doing that at this time. The bond's gonna be set at $15,000, and if he needs a modification, it can be addressed with his attorney and the division judge. There is going to be an order of no victim contact. Mr. Dixon, so that you understand that order, it means no being in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand that?
Yes, sir.
All right, thank you very much. Good luck to you. Garfield Richards. Thank you.
I'm sorry, who did you call, Judge?
It's Garfield Richards.
Mr. Garfield, Judge, he's approaching and we've asked him twice, he wants to represent himself.
That's fine.
I didn't understand.
All right, good morning, Mr. Richards.
Yes, sir. Yes, ma'am.
Mr. Richards, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Ma'am, I really didn't understand it. the advantage and the disadvantage of having an attorney, and so I just thought I'll just come and tell you the truth.
Well, I don't want you to say, hold on. Let me stop you, okay?
Yeah.
I'm gonna say a few things to you. I need you to listen to me very carefully.
Yeah.
Today, we are only here to talk about bond and release
Yeah.
conditions. We are not here to talk about the allegations, the facts of the case, the background. I don't want you to say anything because everything that we say is being recorded and can be used against you at a later date. Do you understand what I
Yes.
just said to you?
Yes, ma'am.
All right. Do you want to have the public defender represent you for today's hearing so that you have attorney representation?
Yes, ma'am.
All right, Mr. Romero, I'm going to give you guys some time to speak to him, and I'll recall him when you're ready. All right, next will be Gerald Walden. Thank you. All right, good morning, Mr. Walden.
Good morning. Yeah.
Mr. Walden, you're before the court this morning on a misdemeanor capias. This is related to a charge for possession of cannabis. I find probable cause, and I will hear from the parties.
Judge, based on this being a cannabis offense, I believe it's a year old. He's wanting to resolve this. We want to see if the state has a plea offer for him today.
Withholding court cost.
He wishes to accept the state's offer, Judge.
All right, Mr. Walden, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Walden, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Walden, what plea do you wish to enter? Guilty or no contest?
No contact.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you, sir. Andre Jones.
Mr. Jones is approaching, Judge. You see our man? Come on up, Mr. Jones.
Good morning, Mr. Jones.
Hello. Good morning.
Mr. Jones, you're before the court this morning on 2 charges. Count 1, resisting an officer, obstructing without violence. 2, failure to obey police or fire department. I find probable cause, and I will hear from the parties.
Judge, in speaking Mr. earlier today, he wishes to resolve this case today.
Is there an offer from the state?
Yes, Judge. The offer is, one moment. It's adjudication time served.
Judge, he wishes to accept the state's offer.
Okay. Mr. Jones, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yeah.
Thank you, and now you can put your hand down. And Mr. Jones, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yeah.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Okay.
All right. And Mr. Jones, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication with time served. Good luck to you, sir. Wesley Killings,
He's approaching Judge Main.
thank you. Good morning, Mr. Killings.
Good morning.
Mr. Killings, you're before the court this morning on one charge of trespassing, or failing to leave property upon order by owner. I find probable cause. And Mr. Romero, what would he like to do today?
Mr. Killings would like to resolve this matter today, Judge.
All right, is there an offer from the state?
Be time served, no return.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. Killings, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Killings, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
All right, have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
Oh.
Okay. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. And Mr. Killings, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication with time served, and there's a no return order to the Wendy's that's at issue in this case. Do you understand that?
Yes.
All right. Thank you very much. Good luck to you, Mr. Killings. All right. We have our Spanish interpreter present.
Yes, Judge.
So
There's two gentlemen here at Maine that require Spanish interpreter, Judge. The first person is on page 9 of the court's docket.
Yes.
His name is Mr. Jose Juarez.
Juarez, okay. And who's the other?
And the second individual is on page 21. His name is Mr. Alessi Exposito.
Esposito?
Yes.
Okay. All right, Mr. Juarez is going to be first. Let me just grab Mr. Esposito's paperwork. He's on page 9. All right, and for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. Alicia's technical.
Thank you. All right, good morning, Mr. Juarez.
Buenos días, señor Juárez.
Buenos días.
Good morning.
You are before the court this morning on 2 charges.
Está frente a la jueza hoy por 2 cargos.
Count 1, domestic battery by strangulation.
Cargo número 1, violencia doméstica por estrangulación.
Count 2, touch or strike battery,
Cargo
domestic
número
violence.
2, violencia doméstica, agresión, toque o golpe.
I find probable cause.
Haya motivo justificado.
And I will hear from the parties at this time.
Y voy a escuchar de las partes en este momento.
I'm requesting a $10,000 bond on count 1,
Estoy pidiendo $10,000 de fianza en el primer cargo
$2,500 bond on count 2,
y $2,500 en el segundo cargo.
no victim contact,
No contacto con la víctima.
based on the level of violence.
Basada en el nivel de violencia.
The defendant choked the victim to the...
La-
Go ahead, choke the victim.
El acusado ahorcó a la víctima,
Which resulted in her going in and out of consciousness.
que resultó en que perdiera la conciencia varias veces.
She believed she was going to die.
Ella creía que se iba a morir.
and 2 of their juvenile children were present when this occurred.
y sus niños menores estaban presentes cuando esto ocurrió.
Nothing further.
Nada más.
All right, Mr. Romero.
Señor Romero,
Judge, I understand the nature of the allegations, that they're serious,
entiendo que son serias la naturaleza de los alegatos,
but in speaking Mr. Juarez, I believe this is the first contact he's had with the criminal justice system.
pero este es el primer contacto que tiene con el sistema judicial criminal el señor Juárez.
Now, he's been married to the victim, his wife, for the past 11 years.
Y lleva casado con la víctima, su esposa, por los últimos 11 años.
And my understanding, he's never been accused as far as any prior acts similar to this.
Y entiendo que nunca ha sido acusado de actos similares a esto.
Now, he's been residing in our community for the past 3 years. He's 37 years old.
Y lleva viviendo en la comunidad con los últimos 3 años, tiene 37 años de edad.
He's been working for the same company for the past 2 years, installing granite and kitchen counters.
Lleva 2 años trabajando para la misma compañía, instalando granito y mostradores para la cocina.
He's only making about $13 an hour, though, Judge.
Solamente gana $13 la hora, su señoría.
Now, he has other family members, specifically his nephew, that he's going to be reaching out to help post his monetary bond.
Tiene familia como su sobrino que va a pedirle que le dé su fianza.
His nephew is employed in similar employment installing granite counters.
El sobrino trabaja en el mismo empleo instalando mostradores de granito.
So as you can see, Judge, from him and his family's financial resources is quite limited.
Así que como usted puede ver, él y su familia tienen recursos financieros limitados.
So they're not going to be able to afford what the state has asked for as far as $12,500.
Así que no va a poder pagar lo que el Estado está pidiendo, que son $12,500.
What we were going to be asking the court to consider is on count 1, we were going to ask the court for a $5,000 bond.
Estábamos pidiendo para el primer cargo $5,000 nosotros.
And on the misdemeanor offense, we were going to be asking for a $1,000 bond.
Y en el delito menor, $1,000 de fianza.
So we're going to be requesting a total of $6,000 on Mr. Juarez's behalf, Judge.
Así que vamos a pedir un total de $6,000 a nombre del señor Juárez, señor.
Your Honor, I just checked. Mr. Juarez Tomas has had an immigration hold placed on him.
Acabo de chequear, el señor Juárez Tobás ha tenido una demanda, una detención de inmigración puesto en él.
Mr. Romero, I imagine you're going to advise him. He'll probably be back either this afternoon or tomorrow morning on that.
Y que va a regresar esta tarde o mañana por eso.
I just explained that to him, Judge.
Yo le acabo de explicar eso a su señoría.
All right, the bond on count 1 will be set at $7,500.
La fianza en el primer cargo va a ser fijada en $7,500.
The bond on count 2 will be $2,500.
El cargo número 2 va a ser $2,500.
There will be an order of no victim contact.
Va a haber una orden de no contacto con la víctima.
Mr. Juarez, so that you understand the no contact order,
Señor Juárez, para que entienda la orden de no contacto.
that means no being in the same place at the
Eso
same
quiere
time
decir no estar en el mismo lugar al mismo tiempo
as the alleged victim.
que la víctima, alegada víctima.
The no contact order also means no phone calls or text messages.
La orden de no contacto también quiere decir no llamadas telefónicas ni mensajes textos.
And no third party contact or social media contact with this person.
Y no contacto de tercera parte o por el internet con esta persona.
Do you understand that, sir?
¿Entiende eso, señor?
Sí.
Yes.
All right. Thank you, sir. Good luck.
Gracias, señor. Buena suerte.
All right, our second interpreter case will be Elisne Exposito Inclán. He is on
Senor
page 21.
Exposito?
Good morning, Mr. Exposito.
Buenos días, señor Esposito. Good morning.
You're before the court this morning on 5 charges.
Está frente a la jueza esta mañana por 5 cargos.
Count 1, possession of fentanyl.
Cargo número 1, tenencia de fentanil.
Count 2, resisting an officer, obstructing without violence.
Cargo número 2, resistir a un policía, obstruir sin violencia.
Count 3, driving with a suspended license.
Cargo número 3, guiar con licencia suspendida.
Count 4, failing to drive in a single lane.
Cargo número 4, no guiar por una senda, mantenerse en una senda.
Count 5 is an out-of-state felony hold.
Cargo número 5 es un delito mayor de fuera del estado que lo están deteniendo.
That is a no bond hold out of the state of Louisiana.
Eso no tiene fianza del estado de Luisiana.
I find probable cause.
Hay motivo justificado.
In light of the no bond hold, do the parties wish to be heard on count 1?
En vista de la fianza, de que no tiene fianza por el cargo de Luisiana, ¿quieren escucharse de fianza? No, su señoría, no en este momento, su señoría.
All right, I'll leave the $1,000 bond in place on that count.
Dejo los $1,000 de fianza puesto en ese cargo.
Good luck to you, sir.
Buena suerte usted, señor.
Is there anyone else at Maine that requires a Spanish interpreter?
¿Alguien más necesita intérprete en español?
No, not at this time, Judge.
Okay. Is there, Mr. Miller, do you know if there's anyone at the other facilities?
Yes, Judge.
All right, who do we have?
Mr. Zavata at North Broward. He's on the last page of today's docket.
Last page. Is he the only one?
That's the only one I'm aware of, Your Honor.
All right, let's see. We'll go to North Broward. Okay, good morning, Mr. Zapata.
Buenos días, señor Zapata.
Buenos días.
Good morning.
So, Judge, it would appear that the state attorney has filed an information in this case.
Parece ser que la fiscalía no ha entablado
Changing
el
the charge
cargo todavía o el
to-
cambio de cargo
to robbery with a firearm.
a robo con un arma de fuego.
Yes, I see that. It was
veo eso.
originally robbery with a weapon.
Originalmente era robo con un arma,
It has been changed to robbery with a firearm.
ha sido cambiado a robo con un arma de fuego.
Is that correct, Mr. Linder?
No.
Oh,
Okay.
It
Tell me
was
what,
not filed a robbery with a deadly weapon.
Está entablado como robo con un arma mortífera.
Under the statute, it's robbery with a firearm or deadly weapon.
Bajo el estatuto es robo con un arma de fuego o arma mortífera.
That's what's on the capias.
Eso es lo que está en la orden de arresto.
The jail just booked it as robbery firearm.
La cárcel solamente lo entabló como robo con arma de fuego.
all right.
it's already
I'm
been
going to,
arraigned on the
Y ha
other
sido instruido en la
similar
otro
charge. I
cargo.
guess they split it into two
Similar.
cases. Is that right, Mr. Linder? No?
When he was first arrested, Your Honor, he was arrested on a new charge of robbery with a weapon.
Cuando fue arrestado en el nuevo cargo con arma, con robo con un arma.
There was also an arrest warrant for
También
robbery
hubo
with
una
a
orden de
weapon,
arresto
attempted robbery.
por manipular.
The state filed it as two separate cases.
El cargo fue entablado como dos cargos separados.
The arrest warrant got a new case number, obviously.
La orden de arresto tuvo un nuevo caso, obviamente.
On this case, before the court,
En este caso, frente a la jueza,
Judge Powell originally set a $20,000 bond.
la jueza Powell originalmente fijó una fianza de $20,000.
Pretrial release GPS level 2.
Libertad antes del juicio GPS nivel 2.
No victim contact.
No contacto con la víctima.
I'm asking that the same bonding conditions be
Estoy
placed back on.
pidiendo que las mismas fianzas y condiciones se queden vigentes.
any objection from the defense?
¿Alguna
No, Judge.
protesta de la defensa? No, su señoría.
All right, so I'm going to make the correction on my finding sheet
Voy a corregir mi papel de hallazgos
so that it will read robbery with a deadly weapon.
para que se lea robo con un arma mortífera.
And I will replace the bond and release conditions that were originally set.
Y voy a reemplazar las órdenes de fianza y condición de libertad que fueron fijadas previamente.
So just to repeat those,
Así que para repetirlas,
the monetary bond will be $20,000.
la fianza monetaria va a ser $20,000.
And if Mr. Zapata posts the monetary bond,
Y si el señor Zapata deposita la fianza monetaria,
he'll be placed on pretrial supervision
va a
with
ser
a,
puesto en supervisión de libertad antes del juicio,
with a level 2 GPS
con
monitor.
un monitor GPS nivel 2.
And there will be an order of no victim contact
Y va a haber una orden de no contacto con la víctima,
as originally set.
como originalmente fijada.
So, Mr. Zapata, this essentially puts you in the same place that you were before.
Así que, señor Zapata, esto lo pone en el mismo lugar que estaba antes.
This is basically a technical, a technical change.
Esto solamente es un cambio técnico.
Good luck to you, sir.
Buena suerte usted, señor.
Gracias.
Thank you.
Buenas tardes.
Good afternoon.
All right. Is there anyone at Maine, Paul Ryan, Conti, or North Broward that needs a Spanish interpreter? Okay. All right. Thank you very much.
You're welcome.
And Judge, whenever the court's ready to proceed, we're ready. Mr. Garfield Richards was on recall. I'm ready to
Yes.
proceed on it.
Okay, let's go ahead and take him. All right, Mr. Richards,
Yes, ma'am.
for the record, you are before the court this morning on one charge of aggravated battery where offender knew or should have known the victim was pregnant. I find probable cause, and I will first hear the state's recommendation, and then I will go to Mr. Romero for the defenses.
I see no history, Judge.
Okay?
Based on the physical condition of the victim, I'm seeking a $5,000 bond, no victim contact.
Okay, Mr. Romero?
Judge, I was talking to Mr. Richards as far as the state request. He has no objection, of course. I already told him it's almost considered standard as far as no contact with very few exceptions on the victim, so that's not going to be a problem.
Okay.
He's going to have to find a separate place to live because my understanding is his adult daughter does live there.
Okay.
Judge, he is working though. He makes about $15 an hour. He lives with his wife. His wife is the person that's going to help post his monetary bond. I believe she's a caretaker. Using the services of a bondsman, he's not 100% certain that she may be able to come up with $5,000, but he's certain that if the court were consider somewhere around $3,500, he's certain that she could. So based on that, Judge, based on the fact that he has no prior record, he's a registered voter, I think it's reasonable for me to request $3,500 on Mr. Richards' behalf.
All right, the bond will be set at $3,500, and there will be an order of no victim contact. Mr. Richards, so that you understand the no contact order, I'm sure Mr. Romero has discussed this with you already, but I'm just gonna say it for the record. With respect to this order, that means no being in the same place at the same time as the alleged victim. That includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much. Good luck to you. Okay, next up, I realize this is an MO case, but I'm gonna call him Stephen Fleeg.
He's approaching Judge here at Maine.
Thank you.
Come on up, sir. Right there at the podium.
All right, good morning, Mr. Fleeg.
Yes.
You are before the court this morning on 16 charges. These are all misdemeanor capiases. They are all related to municipal ordinance violations. And Mr. Fleeg, at this time, there is no offer from the city to resolve these cases. So that means it'll have to go to your division judge. So at this time, I'm gonna leave the bonds in place that were set by the division judge. And you can either post that bond or you'll be seeing your division judge with your attorney shortly. Do you understand?
Yes.
All right, thank you very much. Good luck to you, sir.
Oh, yeah.
All right, next up will be Marizier Wilfrank.
He's approached Judge Garrett Main.
Thank
Come on up,
you.
Mr. Wolfrank.
Good morning, Mr. Wilfrank.
Good morning.
You're before the court this morning on a misdemeanor capias. This is related to a charge for driving with a suspended driver's license. I find probable cause, and I will hear from the parties.
Judge, after speaking to Mr. Wolfrank this morning, he wishes to resolve this matter. We want to see if the state had a plea offer for him today.
All right,
One moment, Judge.
okay.
It's adjudication court costs.
Judge, he wishes to accept the offer.
All right, Mr. Wilfrank, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Wilfrank, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney? I'm sorry, I didn't hear that one.
No, ma'am.
All right, do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right, and Mr. Wilfrank, what plea, excuse me, what plea do you wish to enter? Guilty or no contest?
Plead no contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication of guilt with time served. Good luck to you, sir. Rain Stewart.
He's approaching Judge Main.
Good morning, Mr. Stewart.
Hey, good morning, Your Honor.
Mr. Stewart, you're before the court this morning on 2 charges. Count 1 is driving with a suspended license. 2 is a misdemeanor capias that is also related to a charge for driving with a suspended license. I find probable cause, and I'll hear from the parties.
Judge, after speaking with Mr. Stewart, he wishes to resolve this matter. We want to know if the state has a plea offer for him on both 1 and 2.
You withhold on charge 2, adjudication, court cost time served on 1. This will be his first and second.
Let me talk to him about that again.
Okay.
Judge, he wishes to accept his offer.
All right, Mr. Stewart, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, Your Honor.
Thank you, and now you can put your hand down. And Mr. Stewart, do you understand everything we've discussed here this morning?
Yes, Your Honor.
Is anyone forcing you to resolve this case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, Your Honor.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, Your Honor.
Have you ever been treated for a mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, Your Honor.
All right, and Mr. Romero, did you discuss with him the consequences if he receives a third DWLS?
I did.
Okay.
I did, Judge.
All right, and Mr. Stewart, you understand everything that Mr. Romero's discussed with you?
Yes, ma'am.
All right, and what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence as to count 1, which is the new case, will be an adjudication of guilt with time served. As to count 2, which is the KPS case, that will be a withhold of adjudication plus court costs. Good luck to you, sir. Edward Christie.
Approaching, Judge.
Thank you. Good morning, Mr. Christie.
Morning.
You're before the court this morning on one charge of trespassing on property, not a structure or conveyance. I find probable cause, and I'll hear from the parties.
Judge, Mr. Christie wishes to resolve this matter today.
Offers adjudication, 5 days county jail, no return.
Judge, I understand where the state is coming from as far as Mr. Christie, but because I used to see him quite a bit, and but I haven't seen him in quite a while. It's been probably a couple months. Based on that, Judge, would the court consider extending an offer of time served?
It's been a few weeks. And Mr. Romero didn't see him, Mr. Christie, because he came through over the weekend. And I don't know that we really reached a point where going a couple months without getting arrested is really that much of a mitigator?
I don't know about his other cases, but I do see in the probable cause affidavit, it looks like he was, just trespassed from the same location on January 19th.
He'll accept the 5 days, Judge.
Okay. All right. Mr. Christie, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. All right. And Mr. Christie, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today? Do you understand that?
Yeah.
Okay. Have you ever been treated for mental or emotional illness? All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Christie, what plea do you wish to enter, guilty or no contest?
No contest.
Okay, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication of guilt, 5 days in the county jail with credit for any time served, and there will be a no return order to the location at issue in this case. Do you understand that?
Yep.
All right, thank you, Mr. Christie. Good luck to you. Romello Alexander.
He's approaching, Judge Maine.
Thank you. All right. Good morning, Mr. Alexander.
Good morning.
Mr. Alexander, you are before the court this morning on a misdemeanor capias. This is related to a battery charge. I do see that you are set for a status hearing with your division judge tomorrow morning. I find probable cause. Do the parties wish to be heard?
Judge, based on his court date tomorrow, nothing to add from the defense at this time.
All right, thank you very much. Good luck to you, Mr. Alexander. Gabelin, Phil Same.
Medical research, Your Honor.
All right, I've, since we reset him a couple times now, I'm gonna make a probable cause finding and we'll have him reset for bond. Daquan Scarlett.
Broward?
Thank you. Hey, Deputy.
Aye, Your Honor. Mr. Miller.
What are we doing on Mr. Scarlett's case?
Did he speak with you and I told you he wanted to go back?
Oh, Mr. Scarlett went back?
Did you
I'm
talk
sorry,
to
I
him
got
earlier,
confused.
Mr. Miller?
Judge, would ask the court to waive his presence.
Okay.
And pass this through.
Okay, all right, so on Mr. Scarlett's case, I'm gonna make a probable cause finding in absentia, and I'll leave the bond in place. All right, thank you. Philip Valsey Charles.
Thank you, Jim.
Thank you.
He's approaching, Judge. Aaron,
Thank
Maine?
you. All right, good morning, Mr. Valsey.
Good morning, Judge.
You are before the court this morning on an ad charge. This charge is for burglary of an unoccupied dwelling, unarmed. I find probable cause, and I will hear from the parties.
Your Honor, requesting a $10,000 bond. Mr. Valsey Charles has multiple no bond holds, one of which is on a violation of probation for burglary of a dwelling.
Okay.
Judge, nothing to add in respect to the bond amount, but in speaking to Mr. Valsey, I did tell him there was an ad charge. He just wanted to know when was the alleged date of incident and the location of this offense.
This is August 28th of 2019. It is a residence located at 18414 Northwest 13th Street in Pembroke Pines. All right. So the bond will be set at $10,000. There will be an order of no victim contact and no return. Mr. Valsey, so that you understand those orders, the no return order means that you're not to go to the location that I just referenced. And the no victim contact order means whether you know the alleged victim or not, no being in the same place at the same time, no phone calls or text messages, and no third-party contact or social media contact. Do you understand, sir?
Yes, ma'am.
All right. Thank you.
One moment, Judge.
Okay.
Nothing to add at this time, Judge.
All right, thank you. Next will be Wilson Thomas.
North Broward, I believe, Judge?
Let's see.
Judge, I'm going to waive Mr. Thomas's presence. I spoke to him earlier. He has several other bonds already in place. If the court, if it pleases the court, we will not challenge PC and ask that the bond be kept as set.
All right, on Mr. Thomas's case, I'll make a probable cause finding in absentia, and I will leave the standard bond in place. James Anthony,
Maine.
he's just here on count 3, right?
Yes.
He's approaching, Judge.
Thank you. Good morning, Mr. Anthony.
Morning, Judge.
You're before the court this morning on an ad charge. This is for second-degree petty theft. I find probable cause, and I will hear from the parties.
Nothing to add, just the only thing we wanted to know, when was the alleged date of incident on this petty theft?
This is February 15th of this year at the Walmart on Turtle Creek Drive in Coral Springs.
Thank you, Judge.
All right, I'll leave the $25 bond in place, and there will be a no return to that Walmart location. Mr. Anthony, do you understand that?
Yes, Judge.
All right, thank you. Good luck. Dario Hepburn. This is just count 5.
Yes.
Judge, I've been advised it was some immigration law. He bonded?
He should not have bonded. So confinement's telling me he bonded yesterday, and then he was ad charged for the immigration hold, so he should not have been released. Confinement here is telling me unless immigration's already come to pick him up. I'm confirming it in here. Let me just see. Give me one moment. They already picked him up? Okay. He's out because they took him into custody? Okay, all right, ICE picked him up.
All right.
Okay. Do you need me to do anything on my order? No. Okay. All right, next will be Shelby Pratt.
Mr. Pratt is approaching, Judge. You see remain?
Thank you. All right, good morning, Mr. Pratt.
Good morning, John.
Mr. Pratt, you're before the court this morning on 3 charges. Count 1, possession of cocaine. Count 2, possession or use of drug paraphernalia. 3 is tampering with or fabricating physical evidence. I find probable cause, and I will hear from the parties.
Judge, nothing to add at this time.
Anything from the state?
No, Judge.
All right, I will leave the standard bonds in place. Good luck, Mr. Pratt. Levon Morris.
Mr. Morris is approaching. He's here at Main. Come on up, Mr. Morris.
Good morning, Mr. Morris.
Hello.
Mr. Morris, you're before the court this morning on 1 charge of burglary of an unoccupied conveyance, unarmed. I find probable cause, and I will hear from the parties.
It looks like it should be a structure, Judge.
Oh, structure instead of conveyance?
Yeah, it looks like it was a business.
Let me just make that. All right, go ahead, Mr. Linder.
I'm going to be requesting a $5,000 bond. His Broward history includes 2014 theft, 2013 burglary of a structure, 17 and a half months state prison, theft 2013, possession of cocaine 08, possession of cocaine 05, delivery of a counterfeit controlled substance 03. Most of his other drugs previous to that most of his other priors were drug related, Your Honor.
Okay. Mr. Romero?
Judge, unfortunately, Mr. Morris financially is not going to be able to afford any sort of monetary bond. He's indigent. He's homeless at this time. He's currently looking for employment. He's 55 years old. He's been here his whole life. My understanding, though, in speaking to him, he does have a mailing address to make sure he gets future court notice, to make sure he doesn't miss court. It'd be his sister who resides in Lauderhill. But he informed me at this time no one can post his monetary bond, so that's why we're asking if the court would consider releasing him on pretrial release.
What was his most recent prior?
One moment, Judge.
Thank you.
Treese, do you have anything? He's not on my list.
Judge, Mr. Morris did tell me that he has prior contact with the criminal justice system.
I know that he does. I'm just asking when the most recent one was, because Mr. Linder had read me some of them. I just wanted to know the most recent. That was in 2008? Oh, 2018. Did you say that was a violation of probation?
It was failing to repair.
Oh.
Prior to that, I see a violation of probation in 2000.
All right. I'm not going to put him on pretrial. They're telling me that he's got recent failures to appear, violations of probation, 2018 is what pretrial is telling me here. So I'm going to set the monetary bond at $2,500, and there will be a no return order to the location that's at issue in this case. Mr. Morris, do you understand that means that you're not to go to that location?
Can't return to that. Okay.
Yes, ma'am. Yes, ma'am.
Thank you. Good luck to you. Tyrick Turner.
Jail Judge, we have an argument as to counts 1 and 2.
Okay. Good morning, Mr. Turner.
Good morning, ma'am.
Mr. Turner, you're before the court this morning on 10 charges. Count 1, grand theft of a firearm. 2, possession of weapon or ammo by a convicted Florida felon. 3, carrying a concealed firearm. 4, possession of cannabis, 20 grams or less. 5, possession of cocaine. 6, possession of methamphetamine. 7, driving while license suspended, second offense. 8, operating without a valid driver's license. 9 is a misdemeanor capias. That is related to a charge for operating without a valid license. And 10 is for disobeying a stop or yield sign that is not for magistrate. And Mr. Miller, I will hear your arguments as to count 1 and 2.
Count one is grand theft of a firearm. There is mention of the firearm that was recovered having been stolen out of Miami-Dade County, but there is no time frame and no indication that Mr. Turner knew or should have known that the firearm was stolen. Count two is possession of a weapon or ammo by a convicted felon, and there's no indication on the probable cause affidavit that Mr. Turner's ever been convicted of a felony.
Requesting 24 hours, Your Honor.
All right. I will grant the state's request 24 hours to perfect. So, Mr. Turner, that means that this hearing's gonna get reset to tomorrow morning. So I'll see you back then to see if they have any additional information for us.
Thank you, Judge.
Thank you. All right. Douglas Brinez. Is is the booking correct on this? It says between 20,000 and 100,000.
It's a grand, it's just a grand
It's
theft.
just grand
Your Honor.
theft. Okay. I just wanted to make sure. All right. Good morning, Mr. Bernez. You're before the court this morning on 2 charges. Count 1 is grand theft. 2 is fraud, attempting to use ID of another person without consent. I find probable cause, and I will hear from the parties.
Judge, in speaking to Mr. Brunez, we've been talking a while. He's 100% certain his family cannot afford $200,000. I was trying to explain to him most people go through a bondsman, use their services. He gave me the information of his 2 sisters that are going to help try and post his monetary bond. I believe one of them is a school teacher. Mr. Brunez is working. He's an Uber driver right now. He's been doing that for about a month. On a good week, he can make up to about $700 for that week. Now, he lives in Miami with his sister, where he's been residing in the same location for the past 8 years. His share of the rent is $500. So just based on his expenses, judging what he makes, that's why I feel confident saying there's no way he can afford $200,000. What I was trying to talk to Mr. Brunez is trying to see the amount his family can come up with if the court were inclined to set somewhere in the neighborhood of about a $5,000 bond. He believes using the services of bondsman, that's something that his family can come up with. That's what we're asking for the court to consider.
5,000, is that what you said?
Yes, Judge.
Is that on each count or total?
Each count.
Okay. All right, Mr. Linder.
That's fine, Judge, but I would ask that the GPS monitor that Judge Tobin Singer ordered remain in place.
Judge, if the court is inclined to do a GPS, the only thing I would want, and I don't know how it can be phrased in a court order, like I said, he's an Uber driver.
I understand, it would be an open schedule.
Okay.
Well, Your Honor, I would ask that it not be an open schedule. I understand Mr. Romero's advising the court that he's an Uber driver. This detective, based on his investigation, has reason to believe that he's part of an organized criminal enterprise.
Does he have any priors?
Looks like most of his priors, including a theft from last year in Dade, were dropped. He did plead out a counterfeit fraud offense in 2009 out of Dade.
Mr. Romero, where does he live?
Let the judge know your address.
600 Northeast 25th Street, apartment 16, Miami, Florida, 33137.
How long have you lived there, Mr. Brunez?
For 8 years.
Do you live there with someone else or by yourself?
I live with my sister.
All right, I'm gonna set the bond at $5,000 per count. If you post it, he'll be placed on pretrial supervision with the GPS monitor. At this time, I'm going to allow the open schedule. But Mr. Brunez, you need to understand that if you don't abide by the requirements that are placed on you by pretrial supervision, or you fail to come to any of your court dates, that can be changed. Do you understand that?
Yes, Your Honor.
All right.
One moment, Judge.
I did, thank you.
Judge, as far as the date of incident on these allegations, when were they?
I'm sorry, say that again?
The date of incident on these allegations.
Hold on, I'll tell you. This is, the specific allegation in this case is March 26, 2019 at JP Morgan Chase Bank, involving a check for $1,500. And that bank is on Pines Boulevard in Pembroke Pines.
Thank you, Judge.
All right, next will be Alonzo Lewis. Good morning, Mr. Lewis. Here before the court this morning on 3 charges. Count 1 is a misdemeanor capias related to a petty theft charge. 2 is grand theft. 3 is a misdemeanor capias for petty theft. I find probable cause. I do see Mr. Lewis has a status hearing with his division judge tomorrow morning. Do the parties wish to be heard?
One moment, Judge.
Okay.
Judge, in speaking Mr. Lewis, in reference to counts 1 and 3, which are the misdemeanor offenses, he's wanting to know if the state has a plea offer for him today in order to resolve the 2 misdemeanor offenses.
One moment, Judge.
Okay.
Your Honor, because one of them involves restitution, I think it'd be best that he go to his assigned judge.
All right. All right, so Mr. Lewis, you'll see your division judge tomorrow morning. Okay, good luck to you, sir. Next up will be Marvin Rodriguez, North Broward. Good morning, Mr. Rodriguez.
Good morning, Honor.
Mr. Rodriguez, you're before the court this morning on 1 charge of burglary of an unoccupied conveyance, unarmed. I find probable cause, and I will hear from the parties.
Give me a moment, Your Honor. I need to put his information in the system.
Okay.
Judge, while Mr. Linder's doing that, I'm gonna call my client.
Okay. Mr. Rodriguez, Mr. Miller's going to call you on the phone there at the jail so he can speak to you privately for a moment, and then you'll come back to the podium.
Okay.
Your Honor, I'm requesting a $3,500 bond. Mr. Rodriguez in 2013 had a burglary of a dwelling, grand theft, and felony criminal mischief out of Dade County. He violated his probation in that matter. 2013.
All right, Mr. Miller.
Thank you, Judge. So this is a 2-year-old case. It stems from an incident in April of 2018. It was an out of custody probable cause affidavit and a not in custody information. Mr. Rodriguez lives at the address in the probable cause affidavit, right address, wrong apartment number. And he has lived there for 3 years. So he had changed his current address. He's been there for 3 years.
Okay.
He is a lifetime resident. He was born and raised in Miami. He is a full-time commercial diver. He builds seawalls for a living. He does have a wife and 4 children. Their ages range from 2 to 11 years old. I ask the court to set the bond, in this case, at $1,000, please.
All right, I'll set the bond at $2,000, and there will be an order of no victim contact, just in an abundance of caution.
Thank you, Judge.
You're welcome. Mr. Rodriguez, just so you understand the no victim contact order, whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with that person. Do you understand that? Okay. All right. Thank you very much, sir. Good luck to you.
Judge.
Thank you. Raul Capote.
North Broward, Judge.
Okay.
I spoke with Mr. Capote a little while ago.
Good morning, Mr. Capote. All right, Mr. Capote, you're before the court this morning on a misdemeanor capias, as well as 2 court orders, which I believe those were issued by Judge Porth. Is that correct?
Yes, Your Honor.
And there's an out-of-county felony hold as well, and that is out of Dade County. I do see that Mr. Capote, first of all, I find probable cause. I do see Mr. Capote has 2 no bond holds. Is that accurate from Judge Porth?
Yes, Judge. He has a court date next week with Judge Porth, so
Okay.
we're asking the court to take no action here today.
All right. Anything from the state? No, Judge. All right. So, Mr. Capote, I'm going to leave everything as it is, and you're going to see your division judge within the next few days so that you can address these matters. All right. Good luck to you, sir. Next will be Ismail Pagan.
I understood that was reset for the afternoon, Judge. Oh, wait, I'm sorry. I'm looking at the wrong case. Never mind.
Thank you. Good morning, Mr. Pagan.
Good morning.
Mr. Pagan, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied dwelling unarmed. 2 is second-degree petty theft. I find probable cause, and I will hear from the parties.
Your Honor, I'm requesting a $7,500 bond on the burglary dwelling. This involves someone's residence. The booking sheet says Mr. Pagan is at large. The probable cause affidavit says he resides in Jacksonville. He had a battery last year in Clay County, showing priors out of Putnam County, Duval County, and a lengthy history out of the state of New York.
Mr. Romero?
Judge, I definitely know Mr. Pagan's not gonna be able to afford $7,500. From what he advised me, he's financially indigent, he's homeless at this time. He's been residing, though, in South Florida for the past 4 months, but in the state of Florida, he's been here since 2001. He comes from Jacksonville. Now, he's 47 years old. Like I said, he's looking for work. He doesn't have, right now, any means to post any sort of monetary bond, and he doesn't know anyone that he can contact anyway. He did advise me, though, he has a friend that he can use his mailing address to get future court notices to make sure he comes back to court. But as far as financially speaking, Judge, there's nothing he can afford or no one that's willing to post a bond.
So do you have a recommendation?
Judge, the only thing he can be requesting is pretrial release.
Based on the fact that this is someone's home and Mr. Pagan doesn't have a permanent address, I understand his financial constraints, but based on the circumstances, I'm not comfortable with just releasing him to pretrial. The bond is going to be set at $3,500. There will be an order of no victim contact and no return. Mr. Pagan, so that you understand those orders, that means that you are not to return to the location at issue in this case. And whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
Thank you. Jonathan Swan.
He's approaching Judge Maine.
Thank you. All right. Good morning, Mr. Swan.
Good morning.
You're before the court this morning on 2 charges. Count 1, burglary of an unoccupied dwelling unarmed. 2 is first-degree petty theft. I find probable cause, and I will hear from the parties.
Your Honor, I'd be requesting a $10,000 bond, but whatever bond you said, I'd ask it should be higher than Mr. Pagan's. Mr. Swan is clearly more culpable in this situation. He planned this burglary. It was done in retaliation. I'm concerned for the safety of the victim, considering Mr. Swan specifically chose this person's home to burglarize out of a civil matter. I don't see any. He has a minor misdemeanor prior from years ago, but my position is based on the argument made.
Okay. Mr. Romero?
Judge, in speaking to Mr. Swan, he advised me there's nothing he can afford. However, he does have an address. Unlike the co-defendant, he has a place to stay. He's been in Florida since 1992. He's 38 years old. My understanding from what he advised me, he has one prior misdemeanor, which happened back in 2012 for a misdemeanor offense. So according to what Mr. Swan told me, his criminal history is basically insignificant. He advised me he's a registered voter here in Broward County. He works when he can doing Postmates, which he described to me as similar to something like Uber Eats. He's been doing that for about like 2 months now. Judge, I'd be asking, even though he said he can't afford At the very least, Judge, I'm going to be asking for the court to consider something similar to the co-defendant, $3,500. But I'd ask you to take into account his strong ties to the community, his lack of criminal priors, and the fact that he financially really can't afford anything.
All right, well, taking those factors into consideration against the allegations that have been made against Mr. Swan, I'm going to set the bond on count 1 at $5,000. There will be an order of no return and no victim contact. Mr. Swan, so that you understand those orders, that means that you are not to return to this location. And with respect to the no victim contact order, whether you know this person or not, that means no being in the same place at the same time as the alleged victim, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes.
Thank you. Andres Rafael?
He's approaching, Judge, here at Maine.
Thank you. Good morning, Mr. Raphael. You're before the court this morning on 3 charges. Counts 1 and 2 are felony warrants for violations of pretrial, which have no bond holds. Count 3 is second-degree petty theft, third or subsequent offense. I find probable cause. In light of the no bond holds, do the parties wish to be heard on count 3?
No, Judge.
Judge, at this time, I explained to Mr. Raphael on counts 1 and 2, that's something that he has to take up with his division judge. He's asking on count 3 if the court would consider reducing the bond from $750 to $250.
Since he has to go in front of his division judge to address the violations of pretrial anyway, I think it would be better suited, if it needs a modification, to address it with the division judge at that time. So for now, I'm going to leave it as it is. All right?
Yes, Judge.
Thank you. Good luck to you, Mr. Raphael. Michael Guerriere.
One moment, Judge.
Thank you.
Judge, Mr. Guerriere is here present. He's hard of hearing, that's why I needed to talk to him
That's
close.
okay.
Judge, my understanding is, and I can correct me if I'm wrong, Mr. Guerriere, I believe he's gonna be speaking on his own behalf, and but the court may inquire.
All right. I will try to speak loudly so you can hear me, Mr. Guerriere. Can you hear me?
Yes, ma'am.
Okay. Mr. Guerriere, do you understand that you are entitled to have an attorney represent you for this hearing?
I have a problem with that discussion, ma'am.
What's the problem?
The problem is I'm basically giving power to an attorney, and I'm capable of speaking for self, ma'am.
Mr. Guerriere, if you want to represent yourself, that's fine with me, but I just need to have it on the record that you understand you are entitled to and you have the option of having the public defender represent you. If you don't want them to, that's fine, but I need you to tell me what it is you would like to do.
Could you repeat that, ma'am? You said?
Do you want to represent yourself this morning, or do you want to have the public defender represent you?
No, I wanted to represent myself. That's
Okay.
why I made
Okay, that's all right. Just listen to me though, okay? We're only here to talk about bond and release conditions today. We're not talking about the facts of the case, so I just want you to listen to me for a few minutes while I read the charges. You are before the court this morning on 4 charges. Count 1, having an expired motor vehicle registration over 6 months. Count 2, driving while license suspended, third or subsequent offense. Count 3 is possessing an altered license plate or validation sticker. Count 4 is for improper change of lanes. The last 2, 3, and 4 are not for magistrate. I find probable cause. And Mr. Guerriere, right now, on counts 1 and 2, your bond is set at, it's a total of $775. Do you understand that?
Yes, ma'am.
All right, are you going to be posting that bond or having someone else post it for you?
Do I want to post the bond?
Are you going to be posting that bond or having someone else post it for you?
Yeah, I contact a bondsman. Trying to figure out what's going on.
Okay. All right, so I'm going to leave those amounts in place as they are. I'm not going to change them so that you can contact the bondsman and make the arrangements, all right?
I so appreciate it, ma'am.
All right, good luck to you, sir.
Sorry for the inconvenience. Thank you very,
That's
very
all right.
much. Yes, ma'am. Thank you, sir.
Pedro Van Thienen.
Don't worry. It's okay. Judge, he's here present, Judge, I mean.
Thank you. All right, good morning, Mr. Van Thienen.
Good morning, Your Honor.
You're before the court this morning on 7 charges. Counts 1, 2, and 3 are each a separate count for possessing counterfeit driver's licenses. Count 4, possession with intent to sell, manufacture, or deliver cannabis. 5, possession of THC. 6, possession with intent to sell, manufacture, deliver MDMA. And 7 is for unlawful speed. That is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, in speaking with Mr. Van Thienen, my understanding is he has very limited contact with the criminal justice system, I believe, as a juvie for some drug offense or something like that. But he's been living here in our community since he was 1 year old. He's 18 years old now. He both works and goes to school. He just got a job at a restaurant called All About Empanadas, where he's a cashier, and he's also going to Florida International University in their business program, trying to get a finance degree where he's a freshman. He just graduated from Cypress Bay High School class of 2019. His parents are divorced. He lives back and forth between his father and his mother. Most likely he would be residing with his father, who resides in Sunrise, Judge. Based on the fact that none of these are violent offenses, I don't think he has an extensive record, Judge. I'm going to be asking for the court to consider releasing him on pretrial release.
Judge, it may be a little late, but counts 4 and 6, I was wondering if the court would reconsider probable cause. I don't see anything related to an intent to sell or deliver other than amount, which, as we all know, is not enough. So I'd ask the court to find PC just for possession.
I'm okay with pretrial, Your Honor. I mean,
All right, I'm going to leave the probable cause finding in place. I will ROR Mr. Van Thienen to pretrial supervision, but he will be subjected to random drug and alcohol testing. All right, Mr. Van Thienen, a few things that you need to hear from me, okay? Mr. Romero's given you a piece of paper there, which you'll need to read after we're done today. Though you are going to be released today, you must report to pretrial supervision within 24 hours. If you fail to report to them as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
All right. Additionally, as a condition of your release, you will be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. Do you understand that?
Yes, Your Honor.
All right. Thank you very much. Good luck to you. Next is going to be Carrie Isaac. Morning, Mr. Isaac. You're before the court this morning on 3 charges. Count 1, possession or use of drug paraphernalia. Count 2, resisting an officer obstructing without violence. 3 is a felony capias for delivery of cocaine. I find probable cause, and I will hear from the parties if they wish to be heard. I do see that Mr. Isaac has a status hearing with his division judge tomorrow morning. I assume that's for the felony case, which has a no bond hold.
That's why I informed Mr. Isaac, and I think he was happy to hear that he's going to court so soon tomorrow morning.
Okay, all right, so I will leave everything as it is, and he'll see the division judge tomorrow morning. Good luck, Mr. Isaac. Sam Yonko.
I'm sorry, Judge, who did you call?
It's Sam Yonko.
Oh, no bond. So, Mr. Yanko, come on up.
All right, good morning, Mr. Yonko. You're before the court on 7 charges. Count 1 is a misdemeanor capias related to a charge for possession of cannabis. Counts 2 through 7 are out-of-state felony holds. Those are out of the state of Texas, which have no bond holds. I find probable cause. And Mr. Yonko, I do see you're gonna have a status hearing with your division judge on the misdemeanor case tomorrow morning. And then you will likely go in front of the extradition judge next week so that you can figure out how they're gonna handle the Texas extradition on the other cases. All right, good luck to you, sir. Wesley Danowski.
He's approaching, Judge.
Hey, Sheila, will you find out what time they're gonna need to start? Just one. All right, Mr. Danowski, good morning. You're before the court on 3 charges. Count 1 is possession of THC. Count 2, possession of heroin. Count 3, trespassing on property, not a structure or conveyance. I find probable cause, and I will hear from the parties.
Judge, Mr. Dojnowski is financially injured. He's homeless at this time. He's looking for employment, but he says it's hard to find a job. He has a mailing address that would be of his grandmother, but right now no one's going to be able to help post his monetary bond, so he's asking to be released on pretrial. I see these are drug offenses, so Mr. Dojnowski wouldn't mind also if the court wanted to additionally impose random drug testing.
Hector, could you inquire who his grandmother is?
Alice?
What's that?
Alice?
Okay, just checking, because I've got someone that was born in 1957 that has a permanent injunction against him. Your Honor, he just got out of state prison January 11th of 2020. That was after being sentenced to a year and a day state prison in Palm Beach last year for strong arm robbery and grand theft. Frankly, that alone, Your Honor, I would object to pretrial.
Okay. All right.
And he was upfront with me, Judge. He told me he just got out 2 months ago, and he said he's been looking for work, and as soon as somebody realizes his record, they just turn him away. So he's finding it very hard to find employment, Judge.
I understand, and I understand that that can be difficult and challenging, but, you know, based on the circumstances taken altogether, the allegations and his personal circumstances, I don't want to put him in a position where he's being set up for failure with pretrial. So at this time, I'm going to leave the standard bonds in place. All right, thank you. David Holzberg.
Judge, can we put it on brief recall?
that's fine. I'll go on to the next case, which is Eric Rogers.
He's approaching, Judge.
Thank you.
And Judge, I have an argument as to counts 1 and 2.
No problem, Judge. We'll listen.
All right, good morning, Mr. Rogers. You're before the court on 4 charges. Count 1, possession with intent to sell, manufacture, deliver cocaine. Count 2, possession with intent to sell, manufacture, deliver oxycodone. Count 3, possession of cannabis, 20 grams or less. Count 4 is a felony probation violation, which has a no bond hold. I do see that you have a hearing with your division judge on that matter tomorrow morning. And Mr. Miller, at this time, I will hear your arguments as to counts 1 and 2.
And Judge, it's just a similar argument. He's charged with possession with intent, and there's nothing beyond the amount, I believe, that would indicate that there was an intent to sell or deliver either the cocaine or the oxycodone.
Mr. Linder?
Final PC for possession and $1,000 bonds on each count.
All right. Okay, so on counts 1 and 2, I'm going to find probable cause for possession of cocaine and possession of oxycodone. I'm also finding probable cause on counts 3 and 4. That would lower the standard bonds on counts 1 and 2 to $1,000 each. Mr. Romero, is there anything further that you want to be heard on?
No, Judge.
Okay. All right. Thank you. Good luck, Mr. Rogers. Next will be Brandon Bass.
Mr. Bass refuses to attend, Your Honor.
All right. Well, Mr. Miller, I see these are ad charges. Is your office representing Mr. Bass?
I need to check, Judge.
Okay. He has an out-of-state hold. Yeah, I thought he had a no bond hold on something.
Yes, Judge, we do.
All right. Are you willing to waive his appearance?
Judge, I'm willing to waive his appearance and ask the court to keep the bonds as currently set.
All right. Any objection from the state?
No.
All right. In Mr. Bass's case, I'm going to make a probable cause finding in absentia, and I will leave the standard bonds in place. Thank you.
You're welcome.
All right.
And
Next
Judge, whenever
is...
the court's ready, we're ready to proceed on Mr. Holzberg.
Okay, let's go ahead and go to Mr. Holzberg now then.
He's approaching, Judge.
Thank you. All right. Good morning, Mr. Holzberg.
Good morning.
You're before the court this morning on 1 charge of grand theft. I find probable cause, and I will hear from the parties.
Judge, Mr. Holzberg has advised me he wanted to find out when was the alleged date of incident on these allegations.
This is December 1st, 2019.
It's 2 separate dates,
Oh, excuse me.
December 1st and December 29th.
Yes, that's correct.
Does it say a location?
It's the same Lowe's.
Lowe's in Oakland Park, on Oakland Park Boulevard in Oakland Park.
Judge, in that case, Judge, Mr. Holzberg is requesting if the court would consider releasing him straight ROR, not pre-trial release, but straight ROR.
State would object, Your Honor. The day before this, the day before the December 29th theft, he was arrested for a petty theft at a business called Hobby Lobby. He pled the case out at first appearance, was released on Sunday, the 29th, and upon his release, he then went back to this Lowe's and committed the theft alleged in this matter.
All right. For today's purposes, I'm going to leave the $1,000 bond in place, and there will be a no return order to the Lowe's that is at issue with respect to these charges. Mr. Holzberg, that means that you're not to go to that Lowe's in Oakland Park. Do you understand that?
Yes, ma'am.
Thank you. All right, next will be Milad Ibrahim. Oh, so he should be on our afternoon docket. All right, I'll just, okay, they didn't pull, yeah, okay. All right, so Ladies, will you hold Mr. Ibrahim's paperwork for this afternoon for me? Thank you. All right, Steven Syriacs.
Judge, he's in North Broward. He was in court this morning.
Yes.
I tried speaking with him, and apparently I annoyed him to the point that he left the courtroom.
Okay. Well, I've already reset him once or twice at least, I believe. So I'm going to make a finding of probable cause in absentia, and I will leave his standard bonds in place. Thank you. Silvio Barrios.
It's a medical research, Your Honor.
All right. I'll go ahead and take the correction.
He is another reset on count 3.
Yes.
It should be a $25 bond for expired,
Oh.
DL over 6 months.
Okay.
Change the charge.
Just the $25. Okay.
And over here, so when they reset them, they have a charge.
So it's supposed to be, it's supposed to be expired deal. Okay. All right, what time do the jails need to start for this afternoon? 1:30? All right, so I will see everyone at 1:30.